Good afternoon. I'm Rick Stroop with the King County Law Library. My guest today for What to Expect When is Rosemarie Lemoyne, who's been an attorney for 40 years practicing family law in the Seattle area. And she's here to give us some tips and tricks about family law hearings in the time of COVID-19. So I understand, Rosemarie, you've got some information about technology in particular that you want to talk about.
It's very important if you're using a laptop to be sure your laptop is high enough so that the speaker on the laptop is able to catch your voice. Practice with a friend the day before your hearing. Also, when you're looking at your laptop, be sure that it's at a level so your eyes are level with the camera, maybe even a little higher than the camera. What we don't want is to look at your nose, as we see on CNN sometimes. Somebody's looking down at the camera. Not good. It's a beautiful nose, but we need to see your eyes. And you always want to focus on the camera when you're talking. Be sure that all the distractions are gone in the room where you're at when you're having your hearing. No telephones going off, no dogs barking, no children. Just go into a room where you're by yourself. Be sure the background is neutral. Nothing in the background should distract from your hearing and what you're there asking the commissioner or the judge to decide. And also, if I could, Rick, just about attire for this, what you wear, remember, you may have to stand up. So don't wear shorts or blue jeans. Wear a pair of slacks. Dress as though you're going for a business interview. Conservatively, no t-shirts that are emblazoned with your favorite sports team. While that's great, it's not good for the court hearing. And also, no hats. Hats for a religious purpose, of course, are fine. But hats, you can't wear a hat in the courtroom. Pretend you're in the courtroom, even though you might be in your own living room.
That's a very good point, Rosemarie, the fact that you feel like you're at home, but you're really in a different situation. So,
Very important.
So can you tell me a little bit about the hearing itself? How long does each side have to talk?
Each side gets 5 minutes. But if you are the moving party, if you file the motion, you can ask the commissioner or judge, could I reserve or could I save 1 minute for rebuttal? And the court will alert you when you only have a minute left. And then after the other side is gone, you get to use that minute to respond to what he or she has said.
Thank you. And as a practitioner, how do you prepare for these kinds of hearings? What are the things that you look for and the things you want to do?
The day before, I always read through everything that was filed. I write down notes. I prepare notes for the hearing. You're welcome to write a script for what you want to say at the hearing. Don't get married to your script because sometimes you'll want to, for example, respond to what the other person said. But I write down first and foremost, the first thing you say is, who are you? And then second, what are you asking for? Third, why are you asking that? And fourth, conclude with a summary. You only have a few minutes, so you want to be sure you've written down your most important points. The commissioner or judge will have read the written materials that you've submitted. Be sure not to go off script. You only get to go from what you've said in writing to the commissioner or the judge.
Okay, thank you. And we hear about this word objection come up in discussions of legal matters, and those of us who are the general public really don't know what that means. What is an objection, and what can you object to during a family law hearing?
Well, an objection says that the evidence the other person's offering is not supposed to come in. And the way to make one when you're on a telephone hearing is to very quietly, but to say, objection, Your Honor. You always say, objection, Your Honor. Then wait. The commissioner or judge will call on you and allow you to make that objection. If you're in a video hearing, I would recommend raising your hand and saying objection. So the court knows, okay, this person needs to make an objection. You cannot object, as some people think, because the other side is lying. I've heard that objection before in court. That's not really an objection. But when you do your rebuttal, if you've got that minute, you can point out to the commissioner, this is inaccurate. This is not the truth. But an objection can be made if you hear the other person saying something that was not in his or her written materials. You say, objection, Your Honor. Yes, what is your objection? Mr. Smith is going beyond what he wrote in his written materials, or Mr. Smith is saying more than what he's provided to the court. That's fine. Hearsay is another objection. What children say outside of court is not admissible. So there are very limited exceptions for when that is admissible, and that would take another hour to go over. But for this matter now, remember, hearsay, and you can say objection, Your Honor. Okay, what is your objection? Hearsay, an out-of-court statement offered for the truth of the matter asserted therein. That's another common objection that you'll hear attorneys make.
Okay, thanks, Rosemary. That was really helpful. You mentioned the word rebuttal. Can you elaborate a bit on what that is in this process?
In the rebuttal, I have 1 minute to sum up why what opposing counsel has said is not accurate. It is wrong, why the court should not go with what opposing counsel has recommended, and why the court should adopt the recommendations that I have asked the court to adopt for a parenting plan, or grant the support amount I've asked for. And that's what you use that 1 minute to sum up. If I could go on from there, Rick, because often after that rebuttal, the court will immediately make a decision. A lot of times folks will ask me, when do we get our decision? Normally it's right then and there, and the judge or the commissioner will begin giving you the decision. Write down that decision, take notes. You want those notes. Don't interrupt. Don't interrupt. I've been guilty of that myself, I must admit. But you do not interrupt the commissioner or judge. Wait until they finish. Normally they'll say, are there any questions? If they don't say that, then just politely say, Your Honor, may I ask a question? And wait for the judge or the commissioner to say yes. Then ask the question you have about the decision. Don't argue with the commissioner or the judge. You can file a motion for reconsideration or a motion for revision, but these are also discussions for another time. But you do have avenues of relief, ways that you can say, I don't like this decision. They must be exercised within a certain period of time or you lose that right. But don't argue with the judge. When you address the judge, always say, Your Honor. Just Your Honor is fine, the judge or the commissioner. You always stand when the judge or the commissioner comes in the room if you're in the same courtroom with that person or that official. And in terms of if you're in this courtroom and your opposing party is there, when you're making your argument, you look at the judge, you look at the commissioner. You don't look over. Hey, what's he saying? What's she saying? You just keep your eyes straight on that commissioner. Don't focus on the other party. Write down notes, but don't look at them. And when you refer to them, be very polite. Always be polite. Ms. Smith, Mr. Smith, not, Jerry or Chucky or Mary. It's very formal. It's a very formal proceeding. Same goes if they have an attorney, Ms. Lemoyne. Refer to them by their last name, that just to be polite. And,
Okay.
I don't know if you have any other questions, Rick.
I don't. That was fantastic, Rosemary. I really appreciate you taking the time to do this, and hopefully this helps. So.
Oh, I'm delighted to help. Thank you, Rick. I think the library is fantastic, and thank you for all you do. Thank you.
Oh, you're welcome.
Thank you.